Good afternoon, everyone. Thank you so much for joining us. Today we have Professor Santiago Legarre joining us from the Universidad Católica Argentina. Professor Legarre received his law degree from UCA in 1992 and subsequently earned a master's in legal research from Oxford University and a PhD from Universidad de Buenos Aires. While at Oxford, he wrote a dissertation titled The Historical Background of the Police Power, published in 2007 by the University of Pennsylvania Journal of Constitutional Law. After law school, he clerked for the Argentine Supreme Court, and then he started a career in teaching law at the Universidad Austral in 1995. Legarre moved to UCA in 2007, and since 2012, he's also been a visiting professor here at Notre Dame and at Strathmore Law School in Kenya. Professor Legarre's academic interests include constitutional law and jurisprudence. He also teaches a workshop on creative writing for law students. A special thank you to SCOP and the Rover for helping UCT sponsor today's event. And please join me in welcoming Professor Legarre.
Thank you so much, Megan, for that introduction, and to the organizers, and especially to Tim Bradley, who was key to making the event happen, and of course to all of you, especially my loyal supporters in the front and second row, who every 2 years come to whatever talk I will give in the Founders or either movies or the Rights Life. I did not choose the title for this talk, you could say, as I am from Argentina, where the author of certain children's books is not only not popular, but also completely unknown. I have 8 nephews and nieces in Miami, but then you could dispute that that is, strictly speaking, part of the United States where those kinds of things are read or known. In fact, they do not read them or know them very much, although they think they are American. Plus, Professor Smith told me perhaps it's not such a good idea to have this title for this talk, given that the widow of the author of the books is, according to a source with Planned Parenthood, and or she disputes that her late husband, whose birthday we will all celebrate tomorrow, but in Florida, he did not want his books or Borton's dicta to be, quote, whatever, manipulated, unquote, for pro-life purposes. You can later Google and find out the extent to which these ideas are relevant. I think they are, simply because something similar happens to Dr. Seuss, to what happens with the author of, say, the 14th Amendment. You know, you may write something with something in mind. Maybe you told your wife before you went to bed that what you meant by a person is a person, no matter how small. It's not that what is there within Maria, about to explode any minute, is a person like she and you and me, but rather he had in mind some creatures, you know, a fantasy world and so on. And furthermore, this doctor might have told his wife, no, I never want this to be construed as meaning that the fetus is a person, and even less so for constitutional purposes. And in the same way, it may be that someone finds out that some of the drafters of, say, the Equal Protection Clause in the 14th Amendment were having a beer in a pub, wherever they were drafting the amendments in the East Coast, you know better than me. And one said, you know, when we mean equal protection, when we mean, let's say, when we mean due process, we just mean a procedural thing, it never ought to be construed as saying that the life of a fetus cannot be taken without due process of law. That's not what we intended to mean. Well, that is, in a way, as irrelevant, or even more irrelevant, than what Dr. Seuss told his wife before going to bed that day. Because one, the utterance, the message, the language is up there. It takes a life of its own. And if the original meanings matter, they only matter to the extent that they were actually put, if you want to use a very rough term, in the text that was intended. All the other intended meanings, the ones you utter in a pub or to your wife, or, they are interesting for a historian. They are mostly irrelevant for the law. Now, you could dispute that they are irrelevant for purposes of deciding whether it is manipulating Dr. Seuss to understand that he meant what he didn't mean. Perhaps Professor Smith is right. But the children's story is one thing, and the Constitution, or any law, but especially the Constitution, is a different thing. It has a purpose that Dr. Seuss books do not have. They have a different purpose, as I hope it will be very clear to you. Otherwise, you would be thrilled in law school, and instead you are bored, probably. Okay, that by way of a longish introduction. There are, I say, two types of just things, two types of fairness, two types of justice, just and fair. The first I would call positive, just and fair, but not in the common Dr. Seuss sense of the word positive, but rather as in the expression positive law. So my first example of something that is only just and fair because posited. Pete and Margaret own a big house in town, and they agree with Professor Huber here that they will rent out to him their house for the weekend of the Michigan game, the first weekend of September. And they agree on a $3,000 rate for that rent, which is apparently the market one for this particular house of my friends for this particular weekend, which is why they will probably wait until the game to move. To move as in for good. Imagine how much money there is at stake. You know better than me. So after this agreement, now what is just and fair is that Professor Huber owes them $3,000, and they have the right to collect them from him. This was not just and fair prior to this agreement that they had. It is only so as a result by virtue of this contract. Now, my second example builds on top of this one. Imagine that in the next few months, an economic crisis explodes in your country, let's hope it doesn't. And the President of the United States decides, in the context of this economic crisis, and in order to foster the very important good of game watchers being able to watch the games they want to watch, that there will be a cap on all rents of $2,000, and that this cap will even apply to contracts such as the one between Peter Margaret and Professor Huber, who had agreed on $3,000, but as a result of this executive order that trumps the agreement, so to speak, now Professor Huber only owes them $2,000, and they have the right to collect only $2,000. This is a second way in which something can be just and fair as a result of a positive arrangement, in this case, an enactment by a man in this particular case. Of course, in my second example, where I say that now what is just and fair is that he pays $2,000, I am assuming that there isn't a higher positive law that trumps Trump, so to speak, and has his executive order unconstitutional under Blaisdell, the home building, and so on and so forth. Let's assume that no such thing exists and that under an economic crisis, the president can do such things. And therefore, we have a second example of how something that before the given human act wasn't just and fair, now it is. So in the first example, it's a contract, broadly speaking. In the second example, it's a law, broadly speaking, a law. In this particular case, an executive order. There is a second way in which things can be just and fair. And this second way is not positive, but people in the past at least called it natural, which happens when something is just and fair, not by virtue of convention, that is contract or law, but rather by virtue of what sometimes used to go by the name of reason or nature. So for Aristotle in Book 5 of the Nicomachean Ethics, 3 or 4 centuries before Christ, he would use the expression right reason, and also Cicero, to refer to this. But later, especially the Christian thinkers, starting maybe with the Stoics, they refer to this as natural right and then natural law. So my example for this is more in the ballpark of the topic. Say that Mike and Madeline have a daughter called Anastasia, and they ought to take care of their daughter. Not because there is a contract, not because there is a law. This is a moral ought, the one I mean. Now you could ask my friend, where is it, Barat here, who wrote on why parents morally ought to take care of their children. Now, when Anastasia was still in Madeline's womb, they already had a duty, but again, not a positive duty. It wasn't positive. They weren't told by an executive order that they had to respect, morally speaking, the life of that you want to say that thing. I noticed this many years ago, how in English people refer to a baby as an it, at least many times, and they, especially in the past, they don't attribute a gender to a baby. In Spanish, this is never so, because it is reserved for animals and things. So you would never use that for a baby. But that's a linguistic story that, of course, tells you a lot. So they have this moral, natural duty toward her, and she has, like with Professor Huber and Peter Margaret, a natural right to live when she was still unborn, then to be taken care of, educated. She has this natural right, regardless of convention, regardless of law. Now, the examples that Aristotle gives are completely different, right? For those who are interested, we will blurb here tomorrow, I think, in the Irish Rover, there will be a piece I wrote in preparation for this talk where the examples I use are different from these So I won't tell you what they are. Never mind. What, well, you laughed when I wasn't planning for you to laugh. I was hoping you would laugh at 5 times until now, but it worked.
We got that experience all the time.
Thank you. You know, with students, now this is just between us, you never know if they're understanding your jokes. For my first 5 minutes, I thought they were great.
Totally feel you, right here. Right here.
What are jokes? Yeah, exactly. So, what does law, what does positive law, what does the Constitution, a positive law, do with these things that are right by virtue of reason? In other words, what's the role of law of the Constitution with regard to natural rights? Not natural rights in the sense of the American tradition of natural rights, by the way. That's another story we may revisit later, doubtfully. I mean, the chicken fillet is to blame. So I think you could do one of 4 things, the law, with regard to what is naturally right, morally predetermined as right regardless. Or as they say in Kenya, where I teach, irregardless. The law can ratify what is right. For example, the Argentine Constitution, as you were reading the Rover, says more or less that everyone has the right to life from conception. You can ratify, the law can determine what is already right, as in it can fill the gaps, it can complete what is incomplete. Okay, you have the natural right to life, but what if you're attacked by someone? Doesn't the law have to say something about that? And so on and so forth. But the law can also ignore what is right and can even deny or defy what is right. All of this may happen. All of this is out there, which is why natural law theory allows to pass judgment on what there is without denying that there is, which is why you can say that that is a just law, or you can say that that is an unjust law, still a law, but unjust. I mentioned the Argentine Constitution. What does the Constitution of the United States do with regard to the natural right to life, this moral right and the corresponding duty of annexation? Well, first, one of the things that struck me when I started reading the US Constitution and the amendments, coming from a part of the world where our rights are listed the way I just told you, every person has the right to life in such circumstances. Then I tried to find rights language in the Constitution or in the amendments, and I didn't find much of rights language. Then I also found that everyone was talking about rights, and there were courses on rights, and there is a Bill of Rights, but you only see expressions such as Congress shall not, and and the state shall not, and not much rights language, a bit only. But then all the commentators, the court, the interpreters, for good or for bad, they translate those provisions that are addressed to power in terms of rights. And what about life? Well, there seem to be some references to life in the 14th Amendment, both when the Constitution talks about the equal protection and when it talks about the due process. So in the 14th Amendment, we have the due process clause and the equal protection clause, and the two of them use the term life, right? There are, I think, some reasonable alternative interpretations of these references to life, and then there are several other interpretations. So one interpretation says that I'm far from an expert in this, but I think it would say that when the Constitution refers to life in that context, especially the due process context, it's not protecting life the way I suggest life ought to morally be protected by the law, but rather it's about a fair process, a fair procedure. This was the intended meaning. This is what it meant then. So insofar as you're fair, insofar as you treat everyone equally, you could deprive the unborn of their lives without abridging this particular clause, goes this interpretation. Now, it may be that this interpretation is correct. I don't know. But what I think is that if I were to assume that the substantive due process clause has nothing to do with the right to life, the way we discuss it today in the abortion context, the Constitution would still protect the right to life from whenever life is, according to science, as Justice Blackmun would have it in Roe v. Wade, regardless of what the original meaning of the 14th Amendment was. Why is this so? Well, because the Constitution is out there to, among other things, and probably mainly, to protect real people. I mean, all the other protections for institutions, structural protections, they're all in the service of persons. Whether they are mentioned or not, it doesn't really matter. That's the only point of a just constitution, and I have no reason to think that this is not a just constitution as a concept of what it's there for. And therefore, I could gladly say, even if the original meaning of the 14th Amendment is that, persons are still protected for what they are, whatever they are. The science will tell me when life starts and so on. I don't need to find an article like the one in the Argentine Constitution. I don't have it. And it's not there in the 14th Amendment, goes this interpretation. I suppose this is one reasonable way to go about it, if it's true that the 14th Amendment is unrelated to the right to life. But then, the truth is that those who have denied the right to life in the early stages of human life, they have interpreted the 14th Amendment in a very different way. Not just saying that this is about procedure, but seeing some substance there, enter substantive due process. So, again, whether I agree with this idea that substance can be read into the 14th Amendment or not, I know that this is now the law of the land, at least to a large extent. So I can, as some judges would, under precedent considerations, accept that that is that, even if I wouldn't agree, if I am one of those who think this is only about fair procedures, and then engage these guys, the Justice Kennedys of the world, or the Justice Blackmuns of the world, who read substance and think that the right to life is there, but it's only after the second or third trimester, or when there isn't an undue burden, whatever, depending. And then, reason with these guys in writing, conversation, to explain why it doesn't really make sense to ignore the reality that life starts earlier than that, or when it starts, and conception, whatever. So this is another way in which I think you could reasonably go about this problem and reach the same conclusion, namely that the right to life is one of the rights protected by the US Constitution from whenever science determines that there is human life. That's today, as we, I think, all know, quite easy to determine. Of course, this doesn't solve some practical problems, not least about abortion, but other problems, death penalty, and so on and so forth, that have to do with the different levels of protections of human life during the different times in the life of a person that starts with conception and then until the person dies. You know, when a person is 25 years old, the person can kill someone. When the person is 4 months old in uterus, the person can harm. So innocence, guilt, all sorts of distinctions come in to play, and then that role I mentioned earlier of filling the gaps will be more important. But now you will have a starting point that is completely different from the one in Roe v. Wade, where the court decided that they couldn't pass judgment about what it is to be a person. Then, of course, there are other alternatives, other alternative interpretations of the 14th Amendment, such as, for example, sadly, the late Justice Scalia's interpretation, whereby he would probably agree that the right meaning, the only right meaning is of the protection alluded to in the 14th Amendment. It has nothing to do with the abortion debate, but rather with fairness in the common law sense, and therefore the states can decide. So Roe v. Wade was wrong, he would say, in just the second case, but not because what Justice Blackmun said was wrong. I can't tell, it's not my business to tell, he would say, but rather because he was acting ultra vires, he was writing outside his jurisdiction. This is not a federal matter, but rather something to be left for the states. I think this is a very regrettable conclusion, insofar as now with this position he's dissenting Casey, not only are the lives of those babies in the hands of the states, which I don't think is fair, but also you're not engaging the Justice Kennedys and Blackmans of the world, because you're saying, I'm not entering into this dialogue because this dialogue shouldn't be happening in the Supreme Court. Let it happen in academia and so on. Right. I am about to finish so that I can take some questions. I think I'll skip most of the rest. I'll just say one more thing. The term natural law is a term that has been abused and misunderstood. And this may be a reason, and has been a reason for some persons, not to use the term natural law. Fair enough. But what matters here is the concept of things that are just and fair, irregardless of positive enactments, and not the words. So, for example, let's take the term freedom. If someone says to me, I have the right to abortion because otherwise I wouldn't be free, well, you can call that to be free, if you will. I'm not going to dispute the use of the word. There are some senses in which you're certainly free if you have the right to abort. But let me insist, I would say to the person, that there is still another meaning of freedom in which you are not really free if you indulge in an abortion. I mean, I use indulge in purpose to signal a case where an abortion can be something you indulge in. You can argue that you have the freedom to abort, but I would still insist that there is a sense in which you are only free if you choose to do one thing, something that is right. So something similar happens with natural law. Someone can say, and it has been said, that the reasoning, the majority reasoning in Roe v. Wade is a natural law reasoning. Well, that won't be a reason for me to give up natural law reasoning. Let's not talk anymore about natural law. Let's not talk about freedom. If we want to have a conversation about what it is to be free or about what the relevance is of natural law, if the use of the terms are going to blur, it's going to blur the what is meant. That is so important. Thank you so much.
We have plenty of time for questions, so.
So on the last point about natural law in Roe versus Wade or any sort of the substantive due process, so would you, just to clarify, would you reject that that's true natural law reasoning, or are you agreeing that it is but just done improperly?
Thank you. I am saying that it isn't, and I tried to explain to you why. That may be called, and it was called by Justice Stewart or Justice Lack, dissenting in Griswold, natural law reasoning. That would apply to not only to the majority in Griswold, but also to the majority in Roe. What is meant there in that derogatory reference to natural law is something I would be very happy to derogate to, namely ignoring the law in favor of what I think is just and fair. That's not what natural law is about. Natural law is about what is really just and fair. And what is really just and fair is, in the first place, to respect positive enactments, unless you can argue really that they are unjust, which that wasn't even at stake there. So that so-called natural law jurisprudence is, in my opinion, rubbish and has no connection with natural law. But you won't argue. I mean, if they want to call it natural law, call it natural law. The same with freedom. So let's drop the labels and let's see why this is a faulty or a good reason. Of course.
Well, no.
Slowly.
If you could, no, perhaps I was wondering, we could say a little bit more about one of the last things you were saying about freedom to do right.
Yeah, okay.
Because you didn't develop, I think.
Okay. You know, law is an undergraduate degree in Argentina, where I teach most of the year, as I was telling my friends earlier. So the example I'll give is for 18-year-olders, and I hope you'll take it as a compliment. I say that there are two ways in which you can be free. Now, this isn't original, but you are free in the sense that you have the ability to choose in an unrestrained way, uncoerced, in that sense, autonomous, genuine, when you can choose between X, which is taking care of the baby. You can instead do Y, which is torturing the baby. You can do Z, which is killing the baby, or you can do A, which is giving the baby you don't want in abortion. Whichever you do, you are free in one relevant sense of doing freedom, of the word freedom, excuse me. But then there is a different relevant sense of the word freedom. You can tell already that in this first sense, a person is free to abort. I'm meaning free in the sense I'm talking about. Then there is a second sense where to be free is when you have these options that are taking care of the baby, nursing the baby, torturing the baby, or killing the baby. You are free if you choose either A or B in an unrestrained way because you want to. But if you choose C or D, You are free in this first sense, but you are not free in this second sense, because in this second sense, freedom is only about choosing choosing one among several alternatives that will make you a better person. All the other alternatives, torturing, killing the baby, that will make you miserable after you indulge in them, then they are not really making you free. They are enslaving you to your propensity against children or whatever. So what I said earlier had to do with this second meaning of freedom that some people call moral freedom. In the present discourse, unfortunately, in my view, this second meaning has gone. To be free is to do whatever you want to do. Does that help?
Yes.
Yeah.
So you were saying earlier that the positive law can recognize the natural law, and I'm assuming it can also recognize it only partially.
Yeah.
So if the framers of the 14th Amendment only recognize, let's say, a right to life partially in the sense of process, I guess by what authority do the judges, sort of read more into the 14th Amendment than the people who created it read into it?
Thank you, Dion. That's a great question. By the authority and the duty that they have to serve the people of the United States. So they read, for example, that the Constitution that they ought to respect and uphold grants the equal protection of the laws to all persons, and they just read that as meaning every person. It's not so difficult if you want to do it. Now, this, I insist, doesn't solve multiple problems and puzzles that have to do with the precise protection that each person in different contexts ought to morally receive.
I can push on that one. What happens if they pass a law, unjust law, that
Yeah.
specifically says no fetus shall be protected?
Yeah. Well, I would say first that it's something that deserves being celebrated, that's not the case. And unfortunately, when I read the writings and the judicial opinions of many judges and justices that are indeed completely pro-life, they write and opine as if there were such a provision, but there isn't at all. As you know better than I do, this is the Constitution, not what Justice Blackmun said. What if the Constitution said what it said, say, in Germany in 1933, that some persons are not persons? Well, there comes again that torch, that useful torch, natural law, that will tell you that there is a problem there. And then you will have to, in conscience, decide how you deal with that moral problem, depending on what duties you have according to the positive law of the land and what you swore to do. And some people will come one way and will recuse themselves. Some very famous, beautiful mother of seven, professor and judge, or others will say, I'm not applying this unjust law. I'm not recusing myself. It depends on whether you're at the Court of Appeals, whether you're at the Supreme Court, what kind of precedent is binding you. I don't think I could offer you a general answer to the question. But it is this happened with slavery, this happened with Nazi Germany. It happens today in some countries with abortion, where it is clearly provided for in circumstances that someone has to face that decision. What do I do here? Sometimes the only way not to go against the laws, to be an accomplice of what is about to happen or happened. You don't want to be an accomplice, perhaps. Yes.
Only if nobody else does anything. All right, so let me posit two scenarios. All right, scenario one, the Supreme Court takes a view of the positive rights of children in utero, right? And declares that to be a positive right. This is in equal protection clause should take account of it. Scenario two, the Supreme Court says this is simply not a matter of federal law. We're willing to overturn Roe versus Wade, but this should go to the states. And the states, all 50 of them, as a matter of their own state systems of law, protect children in utero. Is it necessarily a part of your argument that scenario A is more just, more fair than scenario B?
Remind me scenario A.
So scenario A, the Supreme Court, as a matter of affirmative federal law, federal constitutional law, declares the lives of the unborn to be worthy of or necessary of protection under the 14th Amendment. But in scenario B, that the judges say that federal constitution has nothing to say to that. It's a matter of the states take it.
Which would be the situation right now, except that in your hypothesis, all states would.
Well, I mean, right now, the Supreme Court.
Oh no, of course.
Said one of the opposite, right?
Yeah, I mean, it's Justice Scalia's system.
Right. Yes.
The second. Okay. Yes, in answer to your question, I think the first of your two hypotheticals would be fairer to the unborn and to what it means to have a constitution that says what it says. I mean, if the Constitution said what Justice Scalia says, that would be your second hypothetical, well, then I would probably go by that second one as a matter of deference to a law that is suboptimal but not unjust. But the Constitution doesn't say that, and certainly the way it's been interpreted, where it basically federalized everything, including Justice Scalia, federalized so many things. I can see no reason why I would leave it to the states and run the risk that the 50 wouldn't align themselves, as they certainly probably wouldn't. I would certainly, against what so many conservative things, I wouldn't leave it to the legislators of the states. I wouldn't leave it to the majorities of the people in the states.
So to follow up, and this seems then to rest on your view of the appropriate interpretation of a positive enactment like the 14th Amendment, rather than the appropriate division of some sort of principle like subsidiarity.
It would be more, I think, about the appropriate interpretation of the Constitution, because my view is compatible with the view that the 14th Amendment has nothing to do with this, and that Scalia is right. But what is the Constitution there for? It's not there just for an ultra-subsidiary role. It is certainly not that in practice. Certainly not. I mean, does anyone care much about the state constitutions? You're an outsider. We have, yeah, go ahead.
Sorry if you went over this, I came in a little late, but you have thoughts on cases where the unborn being killed, even in trimesters, that have been deemed okay by, for abortion, being upheld as homicides. Thoughts on like inconsistency about that and whatnot?
I am aware of those inconsistencies. I read a bit about that, but I couldn't point you to cases or to more interesting things. I will say though that because I am a friend of nuance, I don't know that I am altogether happy about talking about homicide or, I mean, I said life is, so the protection. Did you have a question too?
Oh yeah, I was going to ask. So let's say Congress tomorrow passed a law that life begins
at the moment of conception? What effect would that have?
Congress, I suppose, here my friends can assist me, but I suppose it should be struck down.
Existing Supreme Court precedent. Yeah.
Under Roe v. Wade and Casey, the Congress has no authority. Under City of Birney, the way they interpret the role of the court is not for Congress to do that. In that sense, I found fascinating the interpretation the court does of its function with regard to the following saga you might be familiar with: Smith, Refra, City of Birney v. Flores. That'll tell you a lot. Do I like that? I do, actually. That is something that, for example, conservatives despise. They think that's not the role of the Supreme Court. I think it is. But I think that Roe v. Wade and Casey got it wrong. So I would interpret a law of Congress saying that just as filling the gaps for what is already implicit here. Justice Scalia would strike it down as much as the majority justices would, I think. If he says, leave it to the states, imagine. Wow, some people seem to be thinking, maybe this is a good time to finish. What do you think?
There's only time for one more question.
Okay, let's risk one more question.
I guess I can ask.
Okay.
If the role of a judge under an unjust law is to refuse itself or to refuse to apply the law, how do we constrain when a judge needs to decide if something is unjust?
How do we
constrain when the judge needs to determine that a law is unjust? Because, I mean, hopefully they be rightly aligned with natural law and natural reason.
Oh.
But if not, that gives us the right to straighten things unjust.
Yeah, I mean, that's crucial. I mean, whoever thinks that something is unjust, unless the person is a phony and a fake, thinks that something is unjust because it's really unjust. But most people get it wrong. So that's a concern. But I can't solve that concern. That concern is about everything. I mean, it's about getting it right about everything. You think that there's someone waiting for you to kill you outside, and you go outside, you go through the window. If you're a reasonable person, you'll get those judgments right. Otherwise, you will be using the windows unnecessarily. So here, it's more or less the same. My argument is no guarantee for people calling just by virtue of reason what is just by virtue of reason. Of course. Which is why natural law to be taught in law school, which is not. Thank you so much.